SJC-11422, Steve and Gavin v. Tewksbury State Hospital, and another.
Thank you.
Morning, may it please the court. My name is Robert Sinsheimer. I'm here before the court representing a family of persons whose father and son starved to death in a Massachusetts state hospital. They are looking for justice, and they're looking for answers. Of course, I'm well aware that I'm here on a very technical aspect, a highly technical aspect, which is whether it was an absolute requirement to bring suit to have a formal estate appointed and an executor named before even serving a presentment letter. And that's a technical question that you, as the highest court of the state, are going to decide. I'm sure you're well aware that there's a split decision at the appeals court. And because I suggest respectfully that the dissent written by Justice Agnes is so well done, I'm going to be very brief, and I'm going to stay away from some of the technical points, unless, of course, you have questions, and ask you to think of two larger themes as you plow through what is a technical question. And the first, at the risk of being just a tad trite, is the humanity of the individuals who have brought this claim. I understand that's true of perhaps in every case. I just ask you not to make light of it because the issue has become so technical that perhaps jurisprudentially, we, myself included, have all lost a little bit of our humanity. And please remember that this is a case about teenage kids who want answers about why their dad died in a state hospital.
Mr. Sinsheimer, you know, the law on presentment is a lot of very difficult cases, which are made, you know, many human stories that are, as you say, of tremendous concern, but have been nonetheless diverted because presentment requirements are considered so important in the context of the statutory scheme of the Mass Tort Claims Act. And there have been many instances where people with very heart-wrenching tales have not been able to present the case to a jury because they didn't make adequate presentment.
Your question, I think, gets right into my second theme. I said the first was the humanity. And the second, I think you used the word diversion, Your Honor. Perhaps it's a little strong to say perversion, but I think Chapter 258 has moved away from its core significance, which is to provide a liberal basis upon which individuals, human individuals, people who have personal injury claims against Commonwealth or Commonwealth entities can find a remedy. Now, let me be more specific and technical to your answer, to your question, Justice Lane, because I think if you go back and you look at that line of cases, Weaver, Vassis, and almost all those cases, they focus on the adequacy of notice. And the end result in almost every instance is, well, if you didn't notify the right person, you can't really blame the state for coming up with a technical defense. But that's not the situation here. This is a situation where if there was error, it was error in the manner and means by which the claimant was identified. And forgive me for believing in the English language that the word claimant to me, as a lawyer with some experience in the Commonwealth, means a person who asserts a claim. And if you look, what are the purposes of 258? They're laid out in Lodge, and they're laid out in the appeals court's opinion. So in the majority opinion, which turns out to be erroneous, but on this point they're correct. 3 points. investigate a claim, settle valid claims expeditiously, and preclude payment of inflated or non-meritorious claims, and take steps that similar claims will not be brought in the future. Now, I suggest respectfully there's not a scintilla of evidence that the Commonwealth in this case has done any of those three things in response to our demand. What they did was wait, and then they hit us with a highly technical defense that is irrelevant to these three purposes, and here's why. If they really wanted to settle the case, you'd call us up and say, you know what, you don't have the right people. In order to get a release, we need a formal estate. But before we get to that little technical point, let's have a mediation, or let's have some dialogue. Let's have some give and take. That's what settlement's about. But that's not what happens. What happens is it gets shuffled from one overpaid state employee. I am not unsympathetic to the bureaucratic realities at all. It gets shuffled from one place to another, and then the adversary process takes over, and there's no incentive to do what the statute supposedly requires of them, which is to actually try and settle the case. Be assured, regardless of the technical defenses that have been put forth, I'm here to tell you, every single human being that could possibly have a stake in this matter. There's no question about that. The only question is whether we jump through the right hoop to get to the merits of the case, which really is about whether a human being should be allowed to die with dignity. You know, there's interesting questions raised by this case. And most respectfully, and I hope I'm not hurting myself, this wasn't one of them when I started the case. It is now, because we're at the highest court of the state and you have to write for the future. But there's a lot of interesting questions, the substantive questions that are raised by the facts in this case, if we're so fortunate as to overcome what, as I see it, a highly technical hurdle. So yes, I'm still answering your question, at least to some extent. Yes, there's a lot of law about the importance of presentment. But there's no law about the definition of the word claimant.
But Mr. Sinsheimer, on that point, the word claimant is used in Section 4, which is the issue here, but it's also used in 3, 5, and 8. And in some of those, it's very clear we're talking beyond the point of the presentment. So if you would say it's technical, but the legislature has used the same word in a whole variety of these connected statute sections. So what do we do about that?
Well,
where it is clear, it is clear that when the suit is brought, I don't think you would disagree, that because it's a wrongful death suit, the claimant, the person bringing the suit has to be the executor or administrator of the estate.
Technically at the end, yes, but I disagree at the beginning, and frankly, Your Honor, it's done all the time, that prior to the formal formation of the estate, the case gets filed to satisfy statute of limitations or because there's problems in the probate court. And I can tell you, I may be going just a tad extra record, and if I am, you'll forgive me for that. I've been called by many, many lawyers who've told me they do this all the time. And I've done it in the past all the time. And I worked for a larger firm where it was done all the time. And I know that the amici feel that this is perfectly appropriate, at least until this case came forward. Now, let me give you a more technical answer. The word claimant, I think, can be analogized to the word plaintiff. It's the same thing. And Rule 17 says, clear as day, if you misname your plaintiff, you get to fix it. And as plain as day, and let's quote the exact language of the rule because I think that's really, really important. And it basically says, no claim shall be dismissed. Well, that's at the beginning of the third sentence of that statute. And what that tells the plaintiff's bar, and what that tells people who want to assert claims in court, that, maybe you have other places where you have to turn square corners, but if you're the real party in interest, and that's the technical phrase, and you mess up, if that's what it comes down to, or you misstate who you are, you have an absolute right under the rules of civil procedure to remedy that. But it's not just Rule 17. It's the Mellinger case, which we've cited. There's other cases that are cited by the Amici. The law is, there's a case that Your Honor wrote in the Superior Court that we cited, Maram, a decision that you wrote that's almost irrelevant to this, but it covers that one key kernel, which is you can substitute. You can substitute freely if the real party and interest changes along the way.
Well, let me ask you this. If this were a federal claim against a federal hospital, and the same thing happened under the Federal Tort Claims Act, would this be a proper presentment?
Yes. And the reason I could say that so clearly is, again, I commend you to Judge Agnes's dissent, who wrote at quite length on the federal. And frankly, when I first briefed it, I understand, of course, that 258 is often analogized to the FTCA, but I just didn't really think it was necessary. I think your jurisprudence clearly indicates, and has over and over and over again, that a plaintiff can amend to name the real party and interest, and that it relates back, and that it's never been a problem until this case came down and was wrongly decided.
Does the Federal Tort Claims Act have the same language that Justice Botsford referenced in terms of the use of the word claimant?
Word for word, I'm going to have to pass. And I send you a letter. I don't have the exact language of the Federal Tort Claims Act memorized. You know, the reality, again, and I was asking you to focus a little more on the pragmatics. When we do the Federal Tort Claims, it's a form. You print a form off the computer and you send it in, and they're very accepting. I've done a number of Federal Tort Claims Act cases, and it's really the most basic of bureaucratic type, you know, get a form in, get a piece of paper in. In fact, we go out of our way almost universally to put a little letter on the back of the form, just in case. But really, it's just something you click out and serve. Whereas here, and I think everyone agrees, apart from the fact that the estate hadn't yet been formed, the letter, if I say so myself, is a good letter. And there's no dispute to that. It puts them on notice. It tells them who the people are that have the claim with a substantial amount of detail.
What would have happened had, instead of the letter that they sent to you, or the two letters that they copied you on, they had sent back and said, this is not a proper claim under the Tort Claims Act because you have not asserted that you're the executor or administrator of the estate, and therefore we don't accept it as a presentment?
I would have written back and said, with all due respect, I can assure you I've met these folks in my office. I have identified them all as either beneficiaries or executors. The case was referred to my office by an estate office. We will begin the process of probating the estate. And if they said, well, you're too late, I would have said, well, we'll find that out at the SJC someday, because I would have filed, I can assure you, without a shadow of a doubt. I would not have accepted that. There was no authority. And, you know, now we're looking back, and I would have said I represent a class of individuals or a group of individuals who, in my mind, as somewhat experienced at the plaintiff's bar, I see as claimants. And I see as perfectly valid claimants. And since you pointed out to me in the good faith adversary process that this is a bureaucratic matter to clean up, we'll be happy to clean it up for you. That's clearly what I would have said. And let me add, Justice Gantz, that has been, and I really want to emphasize this, even if it is a tad extra record, and I think it shows up in the amicus brief, that has been the settlement practice that I've experienced tens, if not hundreds of times in wrongful death cases where the claim in one way or another has been asserted, and fair enough, some of them are insurance defense. I don't mean to suggest they're all 258 cases. I don't mean to be misleading. But the reality is, the case gets going in one way or another, sometimes by dealing with adjusters, sometimes by dealing with lawyers, sometimes even in suit. The case gets going before the estate is formalized. Now, with that in mind, too, I ask you to consider, because I go first, what I consider, and I've been open-minded as best I can, what is the real policy issue that the government may have? Because they write a lot of good stuff, and they're very capable advocates on the technical points, but there's only one that I suggest respectfully matters. And that is, and I agree with them, they shouldn't have to pay twice. And the concern obviously is, if you don't have the right plaintiff or claimant or whatever you call it, then they might wind up paying twice. And I guess there's this Marco case where something like that happened, which keeps the government lawyers up at night.
Well, they actually didn't have to pay twice, I
No,
think.
but I mean, it could, yeah, that's my point. I think Marco helps us as much as we hurts us, and I put that in our brief. But what I'm suggesting to you, and I think it's really even more clear in the matter brief, is that all of that routinely is taken care of at the settlement. No one expects anybody to sign a release that isn't binding. There's nothing that says that concern about double paying has to be ironed out with absolute technocratic certitude before a letter is even sent. The statute says you send a letter and you work it out. And because of all the questions, I didn't get to the larger theme that I think you raised. So in my last sentence, I'm going to say, please take a look at how 258 works in practice. Yes, this is a technical case, but it also raises this broader question. Is the liberal purpose of settlement being achieved in the manner and means that institutionally very good lawyers are addressing these cases routinely? There's an institutional problem that's larger than this technical thing. The cases are not getting settled. And if you do nothing else, when you write win, lose, or draw, please, this case is going to be the estate of Stephen Gavin, and it will be part of the legacy of a man that the Commonwealth killed. And I ask you to give him back at least a little bit of humanity, however you address it. Thank you.
Thank you, counsel.
May it please the court, Mark Sutliff, Assistant Attorney General, representing the Commonwealth in Tewksbury Hospital. There are two issues before the court which can require the affirmance or the dismissal of this case. The first is whether the estate of Stephen Gavin had the authority to bring a Chapter 258 presentment. The second issue is whether the estate of Stephen Gavin and or the Gavins as temporary executors had the authority to bring and maintain the wrongful death action. The interpretation of the word claimant is intended by the legislature to mean not only, as plaintiff asserts, an individual who asserts a claim, but by necessarily implication, it must be a person who has the legal authority to make the claim, and in the instance of a presentment, to settle and so that the purposes of the presentment statute can be achieved.
But how are you prejudiced here?
Yeah.
I'm just trying to figure this out. You've got a lawyer representing the surviving children of someone who has died in a state hospital, claims that there's been a tort committed in connection with that. How are you prejudiced?
Prejudice is not required, as this court has determined under the Tort Claims Act.
Well, I mean, so it doesn't matter. Even if the lawyer contacts you and say, I represent all of the possible beneficiaries of this estate, there's been a terrible incident at your hospital, we're claiming that it's negligence on behalf of the state, please investigate that and essentially come back to us and let's settle the claim. That's not the purpose of the presentment statute?
Judge, that did not happen here.
Okay.
The Commonwealth received a letter saying that a claim was being made by the estate in the names of two children. The letter.
And did you investigate the claim and
Your Honor,
take steps to try to resolve it?
Your Honor, the claim went to the Executive Office of Health and Human Services, which is the Executive Office of Tewksbury Hospital, and I presume, as good public officials, they did what they should be doing. I don't know what they did, but to go
Well,
on
they
to
wrote
answer your-
back, and they certainly didn't say there's a problem with who's bringing this.
There is nothing in the statute that requires a public employer to notify a claimant of a deficiency in a presentment letter, and certainly public employers can't be expected to use their limited resources to contact claimants every time a deficiency shows up in a letter.
No, but it didn't go to the wrong place. It went to the right place. It identified the right hospital, it identified the right
Executive office.
executive office person who was injured, it identified, didn't it?
Timely.
But it did not identify an executor, it did not identify an administrator, it did not state whether all of the beneficiaries and the next of kin were being represented by this lawyer.
So are you saying basically anytime, let's take this out of the context of the wrongful death statute. Let's take it and just say it's a negligence or a nuisance claim.
Yes.
And a party who brings it and does all of the adequate disclosure of all of the relevant facts goes to the right people in the government. The only problem is that it says it's a partnership when it's a corporation. Presentment's no good?
Your Honor, what I would want to know is the person making the presentment, whether they had the authority to effectuate.
So
a
that's not the
settlement.
kind of thing that can be corrected later on?
Your Honor, any deficiency in a presentment letter can be corrected. The statute does not require the public employer to alert a plaintiff to a deficiency. And I suggest here, contrary to the plaintiff's argument, that this was something that was simple and easy for the plaintiff to do, and it should have been known from many decisions by this court, maybe not in the context of a presentment case, but this court in the past had repeatedly said that only a duly appointed personal representative of an estate
And that
has
can be
the-
taken care of. That can be taken care of if the suit is brought in the wrong party's name.
Your Honor,
That can be remedied, right?
you are correct, Your Honor. As I said, any deficiency in a presentment, all the cases in the past where this court has thrown out, for example, sending it to the agency rather than the executive office.
That's the question of who it was sent to, not who it was sent by.
Correct, Your Honor, but it's the same
I haven't
analysis.
got one that says anything about sent by.
Your Honor, it's the same analysis, though.
It's really not, because one interferes with the ability to investigate and the other does not.
Your Honor, it does interfere with the ability.
How?
Because the executive office public lawyer, like myself, could have looked at this letter, and what I did, I said, it says estate of Stephen Gavin. Nothing about administrator, nothing about an executor, and immediately that's deficient. They don't have the authority. I'm not going to use my resources to continue an investigation where this lawyer doesn't have the authority to negotiate and settle the case.
And I'm not going to tell them either that they have a technical problem.
Your Honor, again,
I understand you're saying that, but just think about it.
But that's also not what she did.
Yeah.
She said, I have a claim, said you've submitted a claim and we'll conduct appropriate investigation.
yes, and that
So, and I mean, in Vazis, we said, the defendant's actions may have had the effect of lulling the plaintiff into believing that presentment would not be an issue in the case. And why does this letter from the General Counsel of EOHS not do that? Because they say they referred your claim, will be reviewing your claim to determine whether a settlement offer is warranted, will notify you promptly of the outcome of our review. Why does that not suggest that presentment will not be an issue in this case?
the letter never said presentment was not going to be an issue in the case. And as you look in some of the court's past decisions, that
Well, I mean, I understand that, but it did treat it as if it were a presentment, did it not?
well, no, it treated that it had received a letter asserting presentment. Certainly, there's nothing that letter said that we were not going to raise presentment as a affirmative defense in the case. And what the court must realize as well, the interpretation that
Although we expect to respond to your claim well within the 6-month presentment period of General Laws, Chapter 258. That's what the letter said.
and certainly they didn't do it, but at the same time, if they didn't do it, the plaintiff should have known that they weren't accepting the letter or accepting the claim.
Why should we be tougher than the feds?
Your Honor, the case that was relied upon by the district court, the Massachusetts District Court, refers to a federal regulation. And the federal regulation says an executive or administrator or someone else authorized under state law. This court has repeatedly made it clear that the only person authorized in Massachusetts to make a wrongful death claim is that of a duly appointed personal representative, not a beneficiary, as the federal courts have found.
So you're saying that if this were done at a federal hospital, it would be the same result?
No, I'm not saying that, Your Honor. What I say, it depends upon the state where the law is
Okay,
pending.
but if this were a federal hospital in Massachusetts.
Yes.
And there was a claim made under the Federal Tort Claims Act, you're saying that it would be the same, or the same outcome as here?
I think it would. I think if the court were to apply state law, that should be the outcome. And the point I want to make is that the definition we're advocating to this court is one that is, A, protecting public funds by requiring only those who have the authority to settle case, but also it protects the next of kin and the beneficiaries of the estate so that only the administrator or executive who has been duly authorized can resolve the case, such as what happened in Marco versus Green. You had an individual who was not authorized come in and make a wrongful death case that resulted in the defendant paying over a claim. Now, certainly that if it involved a defendant didn't have other...
But we're not there yet. I mean, at various points along the way, the Commonwealth could say, we can't settle with you because you're not the appointed executor, and we're not going to do that. I mean, but at the outset, I don't see why as Justice Lang says, these things aren't so eminently curable.
Your Honor, first of all, it should never have happened. Plaintiffs should have the burden when they come to public employers to have the capacity they need to effectuate the purposes of the settlement. And it shouldn't be a public employer's risk to, for example, I can see some towns and cities not having the knowledge, settle these claims without knowing that the person didn't have the authority, and then that city and town are out money. It's nothing burdensome for the plaintiffs to have that capacity when they come and make the presentment. It should not be the public employer that has to come to the plaintiff and say, hey, by the way, you haven't done something you should have done. You need to have the required capacity, which reading case law, you would certainly know. The plaintiff could not have walked into any bank, any financial institution and say, I represent the estate of Stephen Gavin, and gotten money or medical records from that institution without the required appointment. And they shouldn't be able to come to a public employer making the same representation and expect the public employer to pay
Or to investigate the claim.
I'm sorry, yes.
Shouldn't expect the public employer to investigate the claim.
Well, Your Honor, again, for all we know, the investigation did occur. The attorney, like myself, called the family and probate court where Stephen Gavin died, saying, is there a estate here? And the reply is no. And the attorney said, okay, they don't have the authority. We're not negotiating with them. That's an investigation.
That's what happened here?
I don't know if that's what happened, but certainly that's what I did, and I presume that that is one of the things that the attorney at EOHS could have done as well. The second ground that we're seeking dismissal of the case is that the action was brought in the name of the estate. The Commonwealth moved to dismiss because the estate did not have the authority to bring the case. While after the motion to dismiss was filed, plaintiff went and obtained a temporary appointment as an executor. The plaintiff opposed the motion and attached a motion to amend the complaint to name the Gavin as temporary executors. That was not sufficient. This court has stated that the only ones that can bring and maintain a wrongful death claim is either an executor under Chapter 192, Section 4, or an administrator under Chapter 193, Section 1. The Gavins were appointed as temporary executors under
They have been appointed as, or one of them has been appointed as the executor, correct?
Your Honor, that is not part of the record, but
Well-
you are correct.
And when did the motion to dismiss enter? The denial of the motion to dismiss enter?
The denial of the motion to dismiss entered after the appointment, but there's nothing in the record.
So the appointment of the co-executors was July 27, 2011, and the entry of the denial of the motion to dismiss was after that?
Correct.
Okay, so that even if the motion to dismiss had been granted on this ground, certainly there was room for the judge to reconsider that upon upon request.
Which was not done.
Well,
Well, the judge ruled on the presentment ground,
Correct, Your Honor, but
and that couldn't be repaired, and there's no relation back. But there'd be relation back if the judge had said, you're not the executor, you can't bring it.
Your Honor, I'm sorry, I lost your question.
If the judge had said, you're not the executor, you don't have the authority as a plaintiff to bring a wrongful death action, and the matter is dismissed, and then they refiled it with the executor,
Correct.
the relation back doctrine would apply, and it would be treated as if it had been filed earlier, so that the statute of limitations would not be violated, correct?
The relation back doctrine does not apply to presentment of claims. This court.
I know that, but it does apply with regard to your second ground of dismissal, which is that it's
I'm
it's
sorry,
the
yes.
wrong party.
Yes, but my point is that it would not have cured the defective presentment.
Well, I understand that,
Yeah,
but if you fail on the first ground and prevail on the second ground, you agree the relation back doctrine would apply.
Your Honor, I would say that the plaintiff had ample opportunity.
Okay, try my question. Would the relation back doctrine apply if you prevailed on the second ground and not the first ground?
Yes, Your Honor. But what I would advocate to this court is that the plaintiff had ample opportunity to make that correction. Didn't. There needs to be an end of litigation.
but the judge didn't rule, the judge didn't rule on that ground.
The reason the judge didn't rule on it is because the plaintiff did not move to amend the complaint to name the executives, nor did the plaintiff move for reconsideration.
Wouldn't have made any difference, you said, because presentment is what you won on, and that's the ground that you won on below.
Your Honor, it's a legal argument. I'm entitled to argue both grounds before this court, and I'm arguing both grounds before this court.
Thank you, counsel.
Thank you very much.
Thank you. We'll take a short recess.
All right.